speakers today. I'll introduce them a little bit more in depth in a moment. But I'm really excited to be hosting this dialogue series. This is number 3 in a number that's going to be happening over the next few months. And today we're talking about the Self-Determination Touchstone. And this one, I think is really important. It's so important that we divided it into 2 parts. But I think it's really important because it talks about sort of the history of how we got here, and also the different ways in which self-determination looks in child welfare. So today we have Terry Cross, who is founder and currently the senior advisor for the National Indian Child Welfare Association, and Sarah Morales, who's a professor and has a doctorate and is an amazing Indigenous lawyer in Canada. And both will be speaking to their perspectives on this touchstone. And just to note about the importance of touchstones for social workers. It is Social Work Month, so I'm really excited that we've gathered a great group of folks here engaged in the field. But I know that from being a part of the beginnings of the Touchstones of Hope, that it really was social workers and people who are working on the ground in the front lines that brought forward this idea of things need to change, things aren't the way that they should be, and our systems are not working for our communities and for our children. The Touchstones of Hope really was a grassroots initiative to bring forward our ideas of transformation, systemic change, and fundamental change in the ways that we do our work. And so I think it's really important for folks who are still learning today, who know that things need to change, to give them some tools and ideas of things that they can do within their own workplace, within their own systems that they operate in. And eventually, I think with enough of us working, we will hit that critical mass and it will change for the better. So that's about all I'm going to say to get us going. We have Terry's bio and intro up on the screen. I'll let you read that, but I remember meeting Terry many, many years ago. I'm starting to lose count. But you know, someone who has been a trusted voice in the field for many years, and someone who gave me an opportunity to become the first youth representative on the board of directors of NICWA, and certainly has a long history and dedication to engaging young people and children in the work. So without further ado, I will hand it over to Terry for his presentation.
Great, thank you, Jocelyn. And it was 16 years ago. And I remember sitting at a banquet, young woman sitting at the table, and we struck up a conversation. And I thought, boy, this young woman has it going on. And so I asked her to come and do a presentation at our board of directors on youth engagement. And it has been a wonderful relationship ever since. So thank you, Jocelyn, for that kind introduction, but also for being part of NICWA for the last 16 years. So I want to talk about this issue of self-determination, and it is I think of self-determination as nearly synonymous with sovereignty. And so I'm going to spend some time talking about that. I'm going to share my screen now because I've got a slide presentation for you. There we go. I want to get back to my beginning screen. There we go. Betty, does that look good? We're good.
Looks great.
Okay. So self-determination, tribal sovereignty, jurisdiction, and I'm going to touch on the Indian Child Welfare Act as well. So I always go back to think about self-determination and jurisdiction prior to colonization. So traditionally, child welfare was about the safety of children. And it was a top priority in our communities. And you can tell that from the stories, from the teachings, from our spiritual beliefs, the teachings, for example, that children were sacred, they were gifts from the Creator, and should they be mistreated, they would be taken back. So we know children were highly valued and seen as our future. The responsibilities for care and discipline and growth and development, they were shared amongst many members of the extended family and the community. So it was not just any single responsibility, and everyone had eyes and ears. Now, uh, all of this operated and was governed by customary law. The notion that laws only came about when the colonists got here is erroneous. Our, our ways of operating, our ways of being were embedded even in our languages as to what was the right way to do things. So this customary law is the basis of our right and authority to make decisions about the well-being of our own children and families. In the United States, the US Constitution recognizes indigenous nations as dependent nation states. I'm a citizen of the Seneca Nation of Indians. The Senecas fought on the side of the British during the Revolutionary War. And at the end of that war, the Senecas were still in military control of most of the state of New York from Utica west. And in order to end the conflict, the new colonies, the new nation, had to negotiate with the Senecas. And in that negotiation, formed a treaty, and only countries can form treaties with one another. So it's established a nation-to-nation relationship that was later incorporated into our US Constitution. Now, we weren't the first. The colonies had entered a treaty of alliance with the Delaware and a treaty of neutrality with the Oneida, but you can see the pattern of establishing this nation-to-nation relationship, so government to government. And as dependent nation states, it was recognized the tribes retained their original jurisdiction, their original right to govern themselves. And so civil regulatory jurisdiction is about the relationships between people. It's business relationships and domestic relationships. So the things like how parents treat their children is included in that original regulatory jurisdiction that's retained from time immemorial. And so we have inherent jurisdiction and can assert that jurisdiction where it's not prohibited constitutionally or limited by federal law. And I'm going to talk a little bit more about that. So this presentation, we're going to examine the history of that inherent sovereignty and what it has to do with self-determination today, and look at that original jurisdiction as the basis for law and policy and what it means in operation to keep our children safe and operate child welfare programs. Now, we have a colleague that is the director of the Michigan Intertribal Association, and his name is Frank Edwagishik. Frank says that all sovereignty is negotiated. And in a colonial environment, the colonial powers are always seem to be trying to erode tribal sovereignty. So even though we were protected in the Constitution of the US, all down through the history, there were attacks on sovereignty. So the Civilization Fund in 1819 was one of the first. establishing, giving grants basically to churches to save and civilize the tribes across the country. Military boarding schools, similar to to the residential schools in Canada, opened in the 1870s. The Dawes Act establishing the allotment process and blood quantum. The Miriam Report was um, a review of federal policy, basically saying that a humanitarian effort should be undertaken, but that citizenship was important to the Indigenous population so they could be absorbed into the mainstream society. So similarly, the Snyder Act establishing broad powers of the Bureau of Indian Affairs, and then citizenship in 1923, something called Public Law 280 in 1952 that allowed states to take over jurisdiction on Indian reservations. The termination policies of the 1950s and the transracial adoption period. Similar histories in other countries, but these were all threats to that sovereignty, that ability to make decisions for yourself. Now things began to shift in the 1960s, and it's closely related in the United States to the civil rights movement, to the war on poverty, to the militancy of the American Indian movement, and the treaty rights decisions like the Bolt decision in Washington State, the sharing of the recognition of the tribal treaties regarding fish, and the Nixon administration's shifting policy, heavily influenced by the Quakers, to establish a policy recognizing that tribes weren't going to disappear and that tribal people had the right to govern themselves. So Nixon administration ushered in an official federal policy of self-determination, turning away from forced and humanitarian, quote unquote, assimilation. So all of this led to a decade of rapid change. There were many, many federal laws passed from 1968 through the early 1980s, but the primary ones were the Indian Education Act, the Indian Self-Determination Act, the Indian Healthcare Improvement Act, the Indian Religious Freedom Act, the Indian Civil Rights Act, and the Indian Child Welfare Act. Now, all of these were mechanisms to help implement this policy of self-determination and get the decision-making and the rights established back in the hands of tribal governments. And so I'm going to focus in on the Indian Child Welfare Act and talk a little bit about where it came from. So in a study in 1976, it was by the Association on American Indian Affairs, it was revealed that because of the transracial adoption and the foster care policies, the assimilation policies of the United States, 25 to 35% of all American Indian children were in out-of-home care, and 85% of them had been placed in non-Indian homes and institutions. So our children were being brought up in a world that wasn't allowing our culture to be known, our languages to be spoken, and the amount of emotional turmoil and problems that resulted from the losses, both loss in our community of our children, but also the losses of the children in their connection to their homes, was found to have devastating impact on the population. And these situations had been it wasn't just a response to social problems, but a coercion of parents to release their children to the system. So the Indian Child Welfare Act was considered in response to this just overwhelming evidence that the loss of our children meant destruction of our culture and of our tribal governments. And so the act itself, Congress acknowledged there was no resource more vital to the continued existence of our tribes than our children. And so the act acknowledged sovereignty. It recognized the tribe's right to protect their own families and children, that inherent right to jurisdiction. It recognized, acknowledged self-determination, that the tribes know best for the needs of their children and families. And it affirmed the trust responsibility. In other words, the federal government being responsibility for the rights and resources of Native people under the Constitution. And it's one thing to have a law passed, it's something quite different to have it upheld. Now, ICWA established a minimum federal standard that states needed to follow when they remove an Indian child from their family. But unfortunately, there was no mechanism of enforcement. Nobody was going to lose any money or face any penalties, and there was no money for implementation. So it was very difficult to get people in states to follow the law. The law did recognize tribes' inherent tribal jurisdiction over child custody proceedings. And it is one of the few places in federal law in the United States where tribal sovereignty is not only recognized, but it's described in the inherent rights the tribes have. So, for example, a tribe has authority and jurisdiction over their tribal members no matter where they are in the country. A tribe in Washington state, if they have a child in Florida, can go to Florida and participate in a court hearing and be a full party to the case. They don't have to, doesn't have to be in their own state. And if they want to license a foster home, they could go to that other state and license a foster home in their own way, under their own authority, as long as that home was a member of their own tribe. So it also provides it also provided for the assistance of tribes to exercise their jurisdiction, to write their own laws, their own codes, to have court, and to establish a child welfare program. But it wasn't enough to function. So some of the other major provisions of the laws that had the states have to identify a child as Native if they have reason to believe that, and then to make active efforts to prevent removal of that child from their home, so to serve the family, to serve notice on the child's tribe that the child's been taken into custody. They have to follow an order of placement preferences, first with the child's own family members, extended family, their own tribe, another Indian family, and or a preference that's established by their own tribe. It allowed for tribal intervention in any court hearing and to become a full party to the case. In other words, the tribe could offer testimony, offer reports, could call witnesses. So they had full authority as a party in the case before the court. It also allowed for transfer of jurisdiction. A tribe could petition a state or county court to transfer the jurisdiction to tribal court. And there's exceptions for good cause, and good cause might be geographic distance or some other intervening situation. The law also required that the acts of a tribal court receive full faith and credit from other courts, from state and federal courts. Now, this in addition to full faith and credit, the law basically says that a tribal court is whatever the tribe says it is. So it doesn't have to look like state or county court. It can be a panel set up by the tribal government. It can even be the tribal government itself. And some tribes actually contract out for court services to other tribes. And in some cases have even had local jurisdictions act as their court for them. And the law allowed for tribal state agreements to enter into legal agreements, government to government, as to how child welfare is going to be handled. And some of these are funding agreements, and some of them are protocols around child abuse and neglect investigations, or it could be around foster care or funding or a whole range of issues. Now, how does this relate to self-determination? Well, the ICWA does not tell tribes they have to do anything. It sets up the opportunity to do things. So a tribe isn't obligated to have a court. It's a sovereign decision as to whether to establish a court. The tribe doesn't have to have a child welfare code, doesn't have to take responsibility for child protection or for custody matters. It's a sovereign choice as to whether to enact a code to do that. It can set up its own order of placement preferences, and under the federal law, states are obligated to follow a tribe's order of preference. A tribe in the US has sole authority to determine who their citizens are. And so in applying the Indian Child Welfare Act, the act it applies to children who are eligible for membership and the biological child of a member of a federally recognized tribe in the United States. So not all children who would be considered American Indian or Alaskan Native are members of federally recognized tribes, and not all of those are eligible as and are biological children of members. So that there's one of the biggest barriers to implementation is kind of who's eligible under the Indian Child Welfare Act. But the important point here in terms of self-determination is whoever a tribe determines its members to be is who is considered eligible under the Indian Child Welfare Act. I think a major self-determination piece. Different philosophies from different tribes about how to implement that. The notion of full faith and credit, acts of a tribal court having, so if there's a tribal adoption, even a customary adoption that's affirmed by a tribal court, then state courts, and for purposes of benefits, a whole range of things, has to recognize that as a legitimate and equal action from one court to the next. And then in these tribal state agreements, the tribe comes to the table to enter into that agreement as a full self-determined party, and as our friend Frank says, all sovereignty is negotiated. You negotiate your best situation for your people that you can. So also under ICWA, I mentioned tribes can license foster homes or other care providers on or off the reservation. And there's a concept of on and near. And so the on and near reservation, the tribe can license anyone, tribal member or not, under their own codes, depending on how that code is written. If it's at a distance, tribes have the authority to license homes that are their own members anywhere in the country. Now, it's not that these aren't tested, that jurisdictions don't argue over this, but these are part of that inherent sovereignty, the inherent jurisdiction that allows this self-determination. The tribes, another thing that's seldom used is that tribes can set standards for other providers as well. If a non-native service provider, say a private agency, is going to provide services to tribal members, the tribes actually have the authority to write standards for how the service will be delivered in their community. And even to the point of licensing professionals. A tribe can assert exclusive jurisdiction, and part of that might be the last bullet here, to retrocede from Public Law 280. Public Law 280 was the law that said that tribes, or that states could elect to assume jurisdiction on reservations. Well, tribes can petition and have that jurisdiction restored. They, in child welfare matters, they may not do that depending on their capacity and their sovereign self-determined choice about whether they want to do that or not. But they would have parallel or shared jurisdiction rather than exclusive jurisdiction if they so claim. If a tribe has exclusive jurisdiction, then the state or county doesn't even come onto the reservation to do services. And I mentioned that the tribe can enact its own laws about child welfare. The right to intervene in state proceedings anywhere in the nation is a strong affirmation of sovereignty. So the tribe's jurisdiction actually extends anywhere in the country. It follows their members. They have the right to intervene in a family by petitioning the tribal court. So they, this is I think, one of the most profound rights reserved under inherent authority to be able to regulate that relationship between parents and their children. They get to decide how services are going to be delivered, what programs are going to look like. Now that's constrained by funding agreements. Every government uses the powers of the purse strings to control how their money is spent. And so tribes have to meet those funding agreements unless they have their own resources to pay for their services. And tribes will decide and determine under their own self-determination the scope of their services. So lots of challenges to all of that. Continuing non-compliance with the laws, particularly in places where there aren't strong relationships between local tribes and local counties or states. One of the patterns we see across the country is if there's a tribe locally, usually there is a good working relationship, not always agreement, between the tribal government and the county or state government on child welfare matters. But where children are at a distance from their tribe, or where, particularly in states where the Indian population is very low and the general knowledge about tribes and the law is very low, then we see more trouble with compliance. We've had many court challenges to the Indian Child Welfare Act. We're facing cases right now where adoption attorneys want to have the right to adopt our children out to non-native families. This is what we see as a continuation of colonial privilege that thinks it's all right to take your land or your natural resources or your sovereignty or even your children. We have a lack of equitable child welfare funding, very similar to your situation in Canada. We estimate that that funding for tribal child welfare is less than 50 cents on a dollar to what the states get. And so it's hard to run your own programs. I would note that one of the main purposes of NICWA has been to advocate for funding and access to the same funds that states get. And since 1990, we've brought more than $3 billion of services to Indian children and families through our advocacy. There's lack of tribal court funding. So only about 2/3 of our federally recognized tribes have tribal courts. There's a lack of trust between tribes and the state, and an ongoing level of racism or implicit bias that gets in the way of believing that tribes actually have the capacity to serve their members. There's a challenge because of funding with regard to capacity and infrastructure, and the continuing colonization mentality. So these are in the same way. I think that all sovereignty is negotiated. All practice is negotiated. We have to be the advocates in every situation, and I think it certainly helps me understand the struggles of our ancestors in maintaining our tribes, and our culture has been a continuous struggle and continues to be, and social workers and child welfare administrators on the tribal side and tribal courts are at the front line of continuing to have that stake in the ground, protecting our sovereignty and our self-determination for our children. And this is my mom, who I lost a couple of years ago, and my grandson, so many generations. I want to always acknowledge them as two of my very best teachers, and wanted to share that picture with you. So I'm ready to turn it over to Sarah at this point. Jocelyn, did you want to jump in there?
Oh, I was just going to do the same thing, just while Sarah's getting her her presentation set up. We also have a slide that has her bio and information. But Sarah and I actually both sit on the Indigenous Bar Association Board of Directors. So we get to talk about all kinds of fun things in law and Indigenous matters in Canada. So again, I won't read her bio. It'll be available, and if people want to, the PDF and the presentations will also be available, as mentioned in the comments, on NICWA's website, and also the recording will be available on YouTube. I'll just make a note that just as we're going through, feel free to ask questions in the chat box, and we'll be monitoring them and asking the questions after this presentation when we do our Q&A. So don't feel like you have to wait till the very end. You can start asking your questions anytime throughout, and we will compile them as needed. So yeah, I will hand it over to Sarah Morales.
Oh, Sarah, you're on mute. Sorry about that.
Oh, sorry about that. Sorry, I'm just having trouble screen sharing. Okay, is that working for everyone there?
We can see it now. Thank you.
Oh, perfect. My apologies. I can't actually see you once I start sharing my screen. So, okay, no, I think I figured it out there. So thank you to Jocelyn for the warm introduction, and for the invitation from the Child and Family Caring Society and NICWA to be part of this important conversation. I'm also so grateful for the opportunity to have learned from Terry this morning. And I was ferociously jotting notes as sort of always a perpetual student, but lots of things and opportunities and questions and comments came to mind. And so I'm excited for a dialogue that we're about to have today, where we can sort of talk about how our experiences in Canada and the United States, though varied, have many similar threads that we can draw from and learn from each other's experience and help each other as we work in this such an important area of thinking about how to reclaim or assert our jurisdiction over our children and families and create healthier societies for those that we love, which is really what this work is all about, as illustrated by the picture that Terry shared in his final slide. So I'm excited to be here today. As was stated, I am a university professor in the Faculty of Law at the University of Victoria, where we've just started a new joint degree program that focuses on Indigenous legal orders, legal traditions, giving a degree in that and a degree in the common law, and thinking about how these laws operate at a trans-systemic level. I'm also a research fellow at the Bokotoan Law and Governance Lodge that's doing a lot of work thinking about children and families. And I am, as stated in my bio, I'm Coast Salish, a member of Cowichan tribes, and I've been working with my own community for the past 10 years or so, thinking about how to reassert jurisdiction and draft and capture our teachings on children and families. So I guess I'll go back to this slide. My remarks today will focus on the act respecting First Nations, Inuit, Métis children, youth, and families, which I'm told that they gave it that name so that nobody would shorten it, so that we'd pay attention to the significance of everything that's contained in that title of that piece of federal legislation. But what's happened is we just continually seem to refer to it as Bill C-92, because that's quite a mouthful to talk about every single time. So I'm going to focus on this new piece of federal legislation that came into force and effect on January 1st, 2020, and how it has changed sort of the legal framework for Indigenous laws jurisdiction in Canada. Those of you in the United States may or may not be aware, but we do not have sort of the same sort of recognition of sovereignty as Native American tribes do within that system. We have constitutional recognition through Section 35 that recognizes and affirms existing Aboriginal treaty rights. And while we would argue as Indigenous people that that contains the right of self-government or the right to be self-determining, the legal process in the past has been that we would have to go to court, each nation, each community, each rights-bearing entity, to argue a specific right to a specific head of power. So for example, if my community prior to this act had wanted to assert jurisdiction over children and families, we would have to go to court to assert that Cowichan tribes has a right to be self-determining over children and families and meet the common law test that had been developed through the common law court system after the Constitution Act of 1982 was ratified, that made those amendments. So we, prior to January 1st, 2020, were operating in a legal framework whereby us as nations, as self-determining people, had laws around children and families, had our teachings, had our stories and songs and art and customary traditions that would prove that, would demonstrate that, which we still relied on within our own homes and family decision-making processes, but that was not recognized as such by the Canadian state. So when this new piece of legislation was passed, when this federal act pertaining to First Nations, Inuit, Métis children, youth, and families was passed, it sort of had two main purposes. One of the main purposes was to set out sort of national minimum standards that would apply all across Canada, all across provincial jurisdictions, that set out minimum practice standards when dealing with Indigenous children. So this involves things like notice, placement priorities, substantive equality, cultural continuity, and so forth. The second main purpose was to recognize the jurisdiction. So this law was really the first time in Canadian history that we see the federal government recognizing that Indigenous people have the inherent right to jurisdiction over their own child and family services. And so this is really going to be the focus of my remarks today, in thinking about how do we unpack this mechanism for recognition that was contained within this act, and what is the work that needs to be done in communities, and what are the challenges in thinking about how this will actually be implemented effectively so it does create real, long-lasting, positive transformations within our communities, for our families, and of course, for our children. And so this recognition that I think the bill was first tabled in sort of June in the summer, and then we sort of had 6 months to prepare ourselves for when this act would come into full force and recognition. And there's a lot of work that goes into drafting legislation for communities. There's a lot of thinking that has to be thought through in terms of coordination of services and mandates between provinces and agencies and Indigenous communities, groups, peoples, nations, etc. And there's a lot of education that has to happen, as agencies will now have to be aware of a variety of laws that operate, especially if they're servicing more urban areas that have a confluence of Indigenous children from many nations. So there's a lot of work to be done. So while there's a huge promise and potential with this recognition of this inherent right that, as I stated, like we already knew and felt that we had, there's still a lot of things that need to be thought through in order to ensure that it creates long-lasting positive change. This slide just really reiterates Terry's comments, and I couldn't say it better, and I don't need to really reinforce this in a different way, but it's important to note that we don't see this piece of federal legislation as giving or granting us the right to be self-determining over our children and families. We assert and acknowledge and know that we were the first legal practitioners in Canada, that we had laws and teachings and dispute resolution practices that continue to have influence in our homes, in our communities today, since time before memory, that we had that authority, that it was granted through sacred sources, through deliberative processes, and that although this act was not necessary to grant us this act does provide a mechanism by which we can exercise that right more freely within the Canadian legal framework. So, one thing I just want to share a quote. I'm on some working groups with our elders currently who help us think through this project and help us think about how we should be drafting our laws or the priorities that we should bring to some of these tripartite tables and negotiating or having discussions with the federal and provincial government. And Albie Charlie, one of our Cowichan elders, said at the last meeting, which was about a month ago, he said to us, I just want to remind you that we're rebuilding our foundation and not creating a new law. And I think, I mean, it's always a gift to hear from our elders, but Albie just reminded us there that, you know, this isn't something new for us. We have the tools, we have the stories, we have the strength within our community to be able to do this work. It's just a matter of standing those laws up next to provincial and federal laws. So one of the sort of first things that Canadian Indigenous communities, groups, or people need to think about is who can exercise this jurisdiction that's recognized in the new piece of federal legislation. And the Act creates sort of a new definition. It references an Indigenous governing body and states that an Indigenous governing body means a council, group, or other entity that is authorized to act on behalf of an Indigenous group, community, or people that holds rights recognized and affirmed by Section 35 of the Constitution Act of 1982. So this is really sort of the first step in exercising the right to be self-determining for nations. This definition means that groups, communities, or people can determine for themselves what their governing body will look like. In some instances, a nation may choose to rely on, you know, the body, the tribal organization that's currently recognized under the Indian Act, right? So it may be the First Nation as defined in that way. Another nation may choose to form a new Indigenous governing body that brings together several Indian Act recognized bands or First Nations. It could be a tribal council. It's a new opportunity for Indigenous groups, communities, or peoples to re-envision for themselves and to draw on past practice and best practices to think about how do we want to make decisions around children and families, or who are our governing bodies, and what is our institution going to look like. And there's freedom to do that within this piece of legislation. The only requirement is that the Indigenous governing body has to demonstrate, usually, you know, through some sort of paperwork, it could be a band council resolution, letters, etc., that it has been authorized to act on behalf of the Section 35 rights-bearing Indigenous group or people. So this is a new opportunity that enables us to really think about how we want to come together, or how we want to work through this area of jurisdiction. As I said, the Act recognizes this inherent right of self-government and specifically says that this authority includes jurisdiction in relation to children and family services, and includes authority for Indigenous governing bodies to draft their own child and family service laws. So there's legislative authority, which is similar to what Terry was speaking about previously, to administer and enforce these child and family service laws, and to provide dispute resolution mechanisms, which we have interpreted as meaning, you know, if we want to create our own tribal court similar to what happens in the States, or a tribunal, or a different type of dispute resolution mechanism, we believe it also gives us the opportunity to mandate who hears these concerns. So perhaps an Indigenous nation doesn't want it to go through a provincial court system, but a federal court system. So perhaps by providing for dispute resolution mechanisms, they can signal there who they want to be the court of first instance in these types of processes, even if they choose at this point in time not to develop their own internal court or decision-making processes. And so, I mean, that's a big, I mean, it's 3 bullets, but there's a lot, as we saw and heard and learned from Terry's experience. There's a lot that goes into that when we think about what it means to draft your own CFS laws. There's a lot that goes into what it means to administer and enforce that. That's a big governance arm that needs to be created. And then again, a lot to think about in terms of internal dispute resolution mechanisms or court systems, tribunals. And so Indigenous peoples in Canada have a lot of choices about the types or extent of child and family service laws that they could pass under the federal act. And this is similar to what Terry was saying, where nations can choose to draw down on certain authorities or not. So some nations may choose to do a comprehensive sort of all-in approach where they will, you know, draft a full suite of laws dealing with both prevention and protection. They'll set up a governance mechanism that enables them to administer and enforce those. They'll develop a service delivery model that can accompany that, and then they may choose to create their own internal dispute resolution mechanism that may mirror a court system or a tribunal, or I've heard some communities thinking about more of a more traditional longhouse decision-making process. That sort of a community can choose to draw down on all of those authorities and fill the void there. Other Indigenous communities, groups, or peoples may choose to take an incremental approach. So they may choose to draw down on some of those authorities. They may choose to legislate. They may choose to develop their own dispute resolution process, but not necessarily the whole thing. They may also choose to focus on specific topics or subjects. So they may take a look at the current provincial legislation that's currently governing their children and families, and just pull out the areas where there's rub that's causing huge issues in their community, and may choose to draft sort of smaller laws that deal with those specific issues. In my community, they talk often about timelines, the timelines that are placed around continuing custody orders or permanent orders that they feel don't allow families to do enough to do the work in a short amount of time to ensure that they get their children back. So it may be something to do with like a specific issue like that. And others may choose to develop sort of a guiding law. So a law that speaks to how the federal act should be interpreted and applied to their children. So not necessarily change the legal framework, but offer an interpretive guide to how those standards and practices and processes should be implemented in a way that accords with their nation's understanding and their Indigenous legal order. And this is not sort of like an all or nothing approach. A community can start incremental and then build up to the point of in 10 years, they may have a comprehensive approach, right? Or a community can say at this point, as we're developing capacity within our nation, we're going to create some guiding documents that will then help to serve as a framework for legislation that we will then pass, right? So it's important to note that as many because this is all about recognizing a nation's right, a people's right to be self-determining, as many communities, nations, peoples there are in Canada, there may be that many different pathways that are going to be exercised to do this work. Within the Federal Act, it becomes clear too that there's sort of two things that have to happen. And this has been our experience with Cowichan tribes as we're doing this work. There's internal work that needs to happen whereby we draw out our laws and our legal processes and our dispute resolution processes. And we consult with community and with knowledge holders, and we make strategic decisions about how we draft that. We then think about services that are needed. And it's sort of this continual process of community engagement. So there's like an internal process that has to happen whereby we draft and create our own laws, and then there'll be an internal ratification process. But then the Act also sets out sort of a series of steps that it expects an Indigenous governing body to go through, or an Indigenous community group or people, whereby in order to assert jurisdiction under Section 18 of this Act, they need an Indigenous community group or people to first identify like whom your Indigenous governing body is, and give notice to the relevant provincial governments and the federal government. You would also, you could stop there and just say you've drafted your law and you give notice, and this is what it is, and then there's steps in place for that law to be made public. Or you could go further and say that your Indigenous governing body wants to attempt to enter into a coordination agreement, which is exactly what it sounds like. In the process that we're going through, it appears as though it's not a self-government sort of sectoral agreement. It's going to be basically a contract around a coordination of services to work out the fine details of who will be responsible for what and whom. Because similar to what Terry explained in the situation in the US, through exercising your jurisdiction, you have the opportunity to define your children as you would want to define them, not necessarily in accordance with what, the Indian Act says around status or so forth. So it may be in the work, we're working through this in Cowichan, thinking about who is a Cowichan child, who is a Cowichan child. How do we define that? And it won't necessarily mirror definitions in the Indian Act, and it may go further. We're currently thinking about different models and ideas about, a one grandparent rule or something to that effect. So it could be that our children, multiply, right? Beyond that, who the children who are necessarily on the band membership code, and that they may be spread further across Canada. And so we need to think about that. How do all of our children receive services, and how do we ensure that our law applies to all of these children? Then they say they're not negotiations to us at these tripartite tables, they're more conversations, but you will have a discussion where you work out sort of a funding model, a coordination of service agreement, paramountcy, things like that, and then it will be implemented. So there's sort of two processes to this. There's the important work that has to be done internally within the community, and then there's the work that needs to be done in thinking about how you will work with the other legal traditions in Canada. And I would say it would even go further, because we will also need to think about how our laws will interact with the laws of our neighboring Indigenous governing bodies and so forth. So once that type of process is gone through, then Indigenous child and family service laws will have certain powers. They'll be deemed to have the force of federal law 1 year after giving notice to enter into a coordination agreement with a certain few stipulations. They'll prevail over all other federal laws in Canada except sections 10 through 15 of the Act that deal with the best interests of the child, the Canadian Human Rights Act, and the Charter, it should state there, and it will prevail over all provincial laws. But there's limits to the recognition of those powers, which I alluded to before. So in order for Indigenous child and family service laws to be recognized as having the force of law and prevailing, sorry, the force of federal law, that should say, and prevailing over provincial CFS laws, they have to give notice of the intent to exercise their lawmaking authority. And they have to either enter into a coordination agreement with the province and federal government or have made reasonable efforts to do so for a year, and be prepared for the minister to make and publish that information on a website or, and so forth. If a nation chooses not to enter into a coordination agreement, this doesn't mean that their laws won't be paramount. It just means that they would have to go to court to prove that a provincial, a conflicting federal or provincial law that conflicts with their nation's law is an unjustified infringement under Section 35. So this pathway just means that those paramountcy rules, those issues around what happens when there is a conflict between laws in a concurrent law model, that they're already predetermined in that way. So just this slide just briefly speaks to the fact that this, as I said, this act came into force in effect on January 1st, 2020. If there is a pre-existing treaty or self-government agreement that contains child and family service provisions, so for example, the Tsawwassen First Nation that passed their Own Children and Families Act as part of their modern day treaty, that pre-existing treaty or self-government agreement prevails in the event of a conflict. So it's just sort of recognizing the primacy of those types of agreements. The Act through Section 4 does allude to the fact that this is a concurrent law model. This means that all authorities that have been permitted to make laws around child and family services in Canada will continue to apply, provided that those laws don't conflict with one another. So in BC, where I'm currently located, the provincial power can pass laws in relation to children and families, and we have the Child and Family Community Services Act. Federal laws apply, which is the act respecting the First Nations, Inuit, and Métis children, youth, and families. And then we'll have IGBs who are creating their own nation-based laws. A concurrent law model means that at any given time, so if there's a Cowichan child, once we pass a Cowichan law, all three of those laws will apply to that child unless there is an express conflict in law between them that makes it unable for all laws to be complied with at the same time. So that means that, like, you can, you know, a law that simply adds something to a regulation without contradicting the other laws, that law is valid. Or if one government has a law that deals with a subject matter or a subject that the others do not, then that law applies. It's only when there's this express conflict between those laws that then the other laws are ousted from that jurisdictional space. So this illustrates right here what that means in practice according to the Act. So at the top is sort of the Charter of Rights and Freedoms, the Canadian Human Rights Act, and the Federal Act, sections 10 through 15 that deal with the best interests of the child. Then an IGB's laws, then an Indigenous law. Then under that, the Federal Act or other federal laws, and then under that, provincial or territorial laws. So this chart demonstrates if there is a conflict or inconsistency between those potentially 3 pieces of legislation operating at the same time, this is how you work through it. Although in practice, I mean, and we've spoken with social workers, and they're very nervous about how they figure this out. How do you work through express conflicts and deciding what standard or law prevails when you're dealing often with very immediate or urgent situations, that it's a lot to sort of have to go through at least 3 pieces of legislation to work through. And there's been call for reform to the Federal Act because they're saying this is going to create sort of another jurisdictional quagmire where our children won't reap the benefits of our laws because of that. But I mean, this is sort of what it means. It means that after an Indigenous law has been passed, the entity responsible for implementing the Indigenous law and delivering child and family services pursuant to the law will have to do it in a way that it ensures with the Indigenous law, the minimum standards prescribed by the Act, the Charter, the Canadian Human Rights Act, and any other minimum standard prescribed by the Act and applicable provincial legislation to the extent that it doesn't conflict or is inconsistent with Indigenous law. So there's a lot to think about here, not only for the service providers who will be mandated with following these laws in the execution of their practice, but also for nations and thinking strategically about how we want to draft our laws in order to ensure that we are fully occupying the space and ensuring that our standards are the ones that prevail. And so I always tell people, I go back to first year sort of law, legislation, and policy and think about how to draft strategically to do that. And this is it. I mean, we know that courts have said that governments can regulate and justifiably infringe our Section 35 rights in Canada. And the Act regulates inherent jurisdiction by imposing the following limits. So the limit that the Charter and Canadian Human Rights Act apply, there's a limit that where a child belongs to 2 Indigenous groups, the Child and Family Service law that the group that's deemed to have stronger ties will apply. And Indigenous child and family service laws will not be applied if they are deemed contrary to the best interests of the child. And it's not although nations in their own legislation can talk to their interpretation of the best interests of the Indigenous child, and that is supposed to inform a decision maker's interpretation of the framework of best interests of the child that's contained in the Federal Act. Nations had a big problem, as you can imagine, with the fact that they weren't the ones who get to define this and have their definition as paramount. But their strategy and drafting for thinking about how to ensure that your nation's understanding of best interests of the child prevails. I want to spend a second. I'm very short on time, so I'm going to wrap this up in 1 minute or less. But to just focus on the stronger ties limitation that was put into the Federal Act. It's meant to answer the question of how should disputes be resolved if more than one Indigenous governing body asserts jurisdiction in relation to a child or a family, what Indigenous laws apply. Under the Act, the law says that the community to which the child has stronger ties prevails. And then it sets out this really obscure test for stronger ties and talks about habitual residence and the child's views, and then the views or preference of the parent or care provider. I have heard from elders in my community talk about this. This is not new for us. We have always intermarried and had close relations with neighboring communities. And there are Indigenous dispute resolution practices that can be drawn from in order to resolve these, and have been in the past and more recent past as well. So I really feel strongly that this issue should be addressed according to Indigenous legal traditions and through protocols between IGBs, and that this is something that nations should be thinking about when drafting their own laws and how to capture that. So our challenges, I won't go into much detail. I mean, the challenges that Terry spoke about are ones that we're also turning our mind to. I mean, capacity, funding, apprehension or nervousness to take on this because of the first two challenges, the struggle against the definition of best interests of the child, how to identify Indigenous children, and how to even know where our children are, how to receive notice of things like that. These are all challenges that we're struggling with as we're attempting to exercise and stand up our laws. This is something that the Wokotowin Law and Governance Lodge has really been thinking about, is just sort of like, what can be our strategies for best practice? And I know that there's a number of social workers on the call today, and we talk about often about the important role that social workers will play in helping nations to really implement effectively their laws and stand them up in a meaningful way. And so this slide just speaks to some of the strategies, which I mean, lots of you are already doing, especially those of you who work for delegated agencies in Canada. I know you have strong relationships with the communities and the people whom you serve, but you know, just this, let's work together, let's figure this out, let's seek out experts, not be afraid to ask questions, and so forth. In closing, I just want to, again, I'm appreciative of the opportunity to hear from Terry, to learn about the experience in the States. I had the opportunity to do my master's and my postdoc in Arizona and Illinois, and learned so much from my experience there. One of my, again, LB Charlie in the meeting last month said, we must continue to strengthen our foundation by working with other nations. And I fully and firmly believe that it's conversations like this, that it's opportunities to speak to those of us who have a long history of working through legislative processes like this. Ours is very new. 1982, we had the recognition of our right. 2020, we get the recognition of this jurisdiction. What can we learn from the experience of our relatives to the south, and how can we strengthen each other's work? So, Haichika, thank you.
Thank you so much, Sarah. So we've had a couple questions. I'll ask those, and just ask if anybody else has questions for both Terry and Sarah to include them in the chat box. You had noted something, Sarah, about some of our challenges, and especially around the when a child comes from two communities. We also challenge and struggle with that, what it's going to look like within the urban spaces, where we have 3, 4, sometimes 5 generations of Indigenous folks living in urban settings, and varying connections to their First Nations, Métis, or Inuit communities. And what does that look like when nations are asserting the jurisdiction? So maybe that's a thought you can kind of fold in as you're answering the questions for both yourself, Sarah, and Terry, how it works for families and communities and children who are in urban settings. So I have one question here. How can advocacy participate in holding child welfare accountable? On the front lines, often policies and laws are not followed. So maybe I'll just ask both of you if you can speak to that, and then I'll take another couple questions and offer them up then. Anyone want to start first?
Sarah, you want to go first?
Oh, sure. I mean, I really think that is the place where that will affect the most change, is those people on the front lines. And I mean, it's there's a lot of unknowns, I will say, in this work to go ahead. I mean, I've been involved with Cowichan tribes for 10 years. Then this act came into force and effect, and we're scrambling and pivoting and trying to ensure that we are doing the best for our community. But we're trying to strongly work with those people on the front lines, with social workers, to help us learn from their past experience about where the challenges have been. We also are working to simultaneously build capacity or education in that way, so that they feel confident to make the changes in practice that need to be made in order to fully implement our laws. And then also just to build strong relationships. We have a project going on in Cowichan that's sort of a side project where we're just meeting with local judges and just educating them on what we're doing so that they're along for the journey. So it won't be that they'll come, you know, after Cowichan ratifies their law, that all of a sudden the law will come before them in a court decision or a court case when they're asked to make a placement decision. It's that they've been aware of the journey, that they've started to develop relationships, that they've had the opportunity to hear from our elders about what family means, about what does it mean to take care of your children. So that's, I mean, relationship building, I think creating avenues and opportunities for connections to foster similar understandings or provide opportunities to share their understandings. I think that will lead to opportunities to ensure that right choices are made when it comes to implementing. I'm not sure if I answered that correctly, but I'm sure Terry will. So I'm going to pass it to him.
Well, I think there are a couple of important issues where there are differences in how the laws are structured. Think about the Indian Child Welfare Act as having two major components. One is a set of regulations that states and counties have to follow when they take an Indian child into custody. So, Jocelyn, your question about what happens to the urban child who's away, well, it's up to the public agency to identify that child's tribal background and identify their tribe, and then the tribe has the option either programmatically or legally and intervene in the court system. And even ask for transfer of jurisdiction. And as I understand this new law there, that this doesn't set up tribal courts, that you'll still have to go to the provincial courts, even though it's Indigenous law. And I think that's a major gap, because having your own court to make your own decisions, it is a major part of self-determination. I can't imagine tribal programs petitioning the county or state courts for decision making. So that's going to be, I think that's going to be a major barrier. Sarah, your point about, I think it's really good to be starting those conversations now, because the judges are going to have whole new bodies of law, and in some cases maybe multiple bodies of law that they have to consider. They may become your allies in getting tribal courts in place, just because it'll be so complex. So I think that this is a great step, and I do agree that there's a number of comments in the chat box about that. Boy, the feds left themselves a big out when they included that best interest of the child provision. It really smacks of colonialism, of we know best, we know better than these First Nations people, so we got to keep this caveat in place that we can intervene and stop their bad decisions if they. That's not really self-determination. That's colonial oversight and it's close. It gets closer, but it just says how much of an ongoing struggle this negotiation of sovereignty is.
Thank you. Yeah, that was definitely going to be one of my comments that I was going to bring up around some thoughts around the best interest of the child, because our history has shown us that the best interest of the child, as defined by colonial institutions, has been used for our removal, not necessarily in our best interests, for sure. I really appreciate that thought. There's another comment, and I wanted to kind of bring it to you on both ICWA and the new act in Canada around funding. And maybe if I could tack on just sort of a personal, sort of itch that bothers me a lot is around the data collection. Long history with ICWA of provisions for data collection, but no implementation. So maybe if you want to comment on, creating space for jurisdiction is one thing, but without the resources to implement that jurisdiction really challenges Indigenous governments to be able to actually see through the plans that they have for their own jurisdiction. Maybe Terry, do you want to talk a bit about the history from ICWA's point of view, and then Sarah, maybe kind of if you have any thoughts on funding with respect to the new act in Canada.
Yeah, I would say just the act itself was passed with very little funding, and so the granting process from the federal government it was a competitive process in the first 10 years or so. Not everybody got grants. You had to write a grant proposal and maybe you got $20,000, hardly enough to do anything. And tribes had to put other resources in. That changed somewhat, but still today there's far too little resources to go around. So, and our NICWA actually developed in response to the Indian Child Welfare Act, because of the need for advocacy, the need for training, the need for networking, need for financing. So our approach was to begin to advocate and then lobby for access to the dollars that states get from the federal government for child welfare. And that meant we had to get a line or two in every piece of federal legislation when a new piece of legislation was passed or an old law was being reauthorized, getting a provision to allow a tribal set aside or a tribal access. So, when I said we'd gotten access to over $3 billion, it didn't come because there was any new Indian money appropriated. It came because we got access to child care and development block grants, and we got to the Safe and Stable Families Act and the provisions of the Social Security Act that help fund child welfare, to the temporary assistance to needy families. So one of our specialties, I think, in our advocacy has been to be there whenever legislation is being passed and try to make sure that there's a tribal provision. And so little by little by little, over 20, 30 years now, we have been chipping away, bringing more and more dollars to tribal communities to operate their child welfare programs.
Yes, I mean, no one can speak better about this issue of funding than the Child and Family Caring Society in Canada. This has been the work that they have done, the attention to detail, the expert reports that they have garnered speak to the huge issue of not only lack of funding, but the problems that insufficient funding creates in the lives of our children, our families, and our communities. Like, it is a linchpin that needs to be resolved. That was a huge frustration about this act, that it didn't create a funding mechanism. The only place where funding is mentioned is in the preamble, which those of you from a legal background know that there is an illegal status to the preamble. It's not meant to to be part of the Act, but it speaks to the fact that Canada acknowledges the ongoing call for funding for child and family services that is predictable, stable, sustainable, needs-based, and consistent with the principles of substantive equality in order to secure long-term positive outcomes for Indigenous children, families, and communities. Again, that's like an acknowledgement statement. It's not a commitment. I will say, we just heard at our last coordination agreement discussion, a presentation by Indigenous Services Canada that talked about the funding model or mechanism, how the funding process will take place once a coordination agreement is signed and part of and been concluded. It sounded very positive, like almost you know, that it was just sort of a matter of us adding up what we would need and submitting that. But you know, because of this long history, we have to take everything with a grain of salt, that's really what will happen, or where's the money coming from is sort of, you know, that's the question I want, but it's, you know, it's not, you know, the other part of me is like, well, just offer or just try and advocate as best as we can for the communities. And that's for the Canadian government to figure out. But that, I mean, it's exactly as people have stated here, right? Without funding that will enable you to provide the services or implement the laws or create the dispute resolution mechanisms you need, then change will not occur in these communities. It is necessary. I will say, not only in terms of executing the law, but there's a governance structure that has to come, at least in Canada, where we have a different system to implement those, especially when you have Indigenous governing bodies that don't mirror an Indian Act model of authority. Like, that will need to be funded. There's capacity building that will have to happen. There's public education that will have to happen. There's a lot of things that will go into making sure that this process is transformative, that don't necessarily have to do with just the, you know, a funding model based on a child in care or a preventative service. It's much more holistic than that, especially when we think about the things that bring our children into this system, that that are poverty, that are socioeconomic conditions, that, you know, there's housing implications. It's huge. I wish I had a better answer, but we're all strategically thinking about how to place our communities in the best position to negotiate that.
Thank you so much. I just noticed we're a couple minutes over time, and we just have, we had a couple of questions that we're not going to be able to get to, but so one was around child whose history has been silenced or buried due to the 60s scoop, thoughts on Jordan's principle and playing an active role in capacity building and funding. And so perhaps if there's any thoughts to add on online, or we can ask maybe our presenters in the next self-determination session to maybe speak specifically to some of those. I think those are really good questions that probably require a lot more than a 30-second response that we have here. So I just want to thank everybody for participating in today's webinar. I really want to thank our presenters, Terry Cross and Sarah Morales. And please check the NICWA website and the Caring Society website for the upcoming future sessions. So the next one's going to be Self-Determination Part 2. And then we're going to move on to some of the other touchstones. And if you want to check out, if you've missed the previous ones, please check out the websites and tune into the previous sessions that we've had. So the next one's going to be on May 18th. And you can register. There's a link in the chat session. So once again, miigwech everyone, to the presenters, to everybody who participated, and look forward to seeing you at the next one. Miigwech.
Thank you, everyone.
Thank you. Take care.